Good day, welcome to this week's edition of Chaile Time, and this week we will be doing a case law review. It's more the educational side of Chaile Time, so forgive me if there's not too many jokes or so forth. Okay, we'll be doing a case law review on a fairly recent Labour Court case that deals with resignations, termination of employment in the context of a resignation in the workplace. Often employers are griping with the issue of employees simply just walking out or verbally resign or showing conduct of, having an intention to terminate their employment relationship or repudiating their contract of employment, but it's not been done in writing. So we'll go through the case in Nathaniel Muguti versus QK Meat South Africa, trading as Dawn Farm, whereby the employee in this case had a argument with his line manager around the 31st of August 2011, and the manager testified that he could see that on the day the employee was quite agitated. So they had a bit of an engagement and altercation with each other, and this also happened in front of another senior member of staff of the employer, and the employee then basically stated that he no longer wants to work for the company. The employer then, or the line manager then asked the employee, but listen, why don't you then hand in your resignation if you have no intention to work here? And he refused to do that, basically saying that he doesn't have the time to actually fill in a resignation form. So he, at the end of a shift, walked out, handed in his access card to the gate, as he has no longer have the intention to actually return to work. And he actually didn't come to work. And around about the 28th of September, which is like a month later, the employer reached out to him to say, listen, he must come and sign his withdrawal forms. A lot of companies have provident and pension funds, and you have to complete a withdrawal form if an employee has no intention to come back to work. And he did. He duly arrived for work and or at the company to complete his withdrawal form so that he can get his provident fund payouts. But very surprisingly, the employee then went to the CCMA to file for an unfair dismissal dispute. And it is this dismissal dispute that eventually was arbitrated by the CCMA, and there was a jurisdictional question raised. Now, in terms of a jurisdictional question, the CCMA does not have its own jurisdiction because they are a creature of statute. So if the CCMA do not have jurisdiction to deal with a certain matter in terms of arbitration, then they cannot actually proceed with the matter. Now, what is interesting is when it comes to review applications, for unfair dismissals, for instance, the test really, or the Sudumo test really is in terms of the reasonableness of this decision, not the correctness of the decision. That's now in terms of a standard or typical review application relating to unfair dismissals disputes. But interesting is that when it comes to jurisdiction disputes, the test is not reasonableness, it is correctness. Either the CCMA have jurisdiction or they don't. If they don't have jurisdiction, they can't actually arbitrate the matter. If they do have jurisdiction, then they can arbitrate the matter. So in this case, the employer then disputed the existence of a dismissal, relying on the conduct of the employee and that there was a verbal resignation on behalf of the employee, or so that was the argument of the employer. Now we're going to go through some case law here. Now the first one is in South Africa Rugby Players Association and others. The Labour Appeal Court articulated this type of inquiry as follows. The issue that was before the Commissioner was whether there had been a dismissal or not. So it is not about the reasonableness of the events of whether a dismissal potentially was fair or unfair. It is just about whether there had been a dismissal or not. It is an issue that goes to the jurisdiction of the CCMA. The significance of establishing whether there was a dismissal or not is to determine whether the CCMA had jurisdiction to entertain the dispute. It follows that if there was no dismissal, then the CCMA had no jurisdiction to entertain the dispute in terms of Section 191 of the Labour Relations Act. In addition, the CCMA is a creature of statute and is not a court of law. As a general rule, it cannot decide its own jurisdiction. It can only make a ruling for convenience. Whether it has jurisdiction or not in a particular matter is a matter to be decided by the Labour Court. Now, here we can already see that, first of all, the CCM is a creature of statute and does not have its own jurisdiction. So there are various kind of challenges that a person or a company can challenge at the CCM as far as their jurisdiction goes. But one of the primary challenges in this context, especially in relation to a dismissal dispute, is against the jurisdiction of the CCM as far as it relates to whether there was indeed a dismissal or not. If there was no dismissal, then the CCM cannot actually arbitrate the dispute. Now, the question arises, when can one accept a resignation in this situation now? Because sometimes, employees don't always articulate that they are now resigning, or, they will just be leaving and don't have any intention of coming to work, or sometimes they'll actually write in a resignation form. But it seems like these days a lot of instances employees actually don't have the decency anymore to actually complete the resignation form, and it leaves the employer sort of between a rock and a hard place. Did the employee resign now? Did he have the intention to actually not come back to work? Or can we now safely assume that he actually resigned if it was a verbal resignation, which is sometimes difficult to prove, and so on. So in Chaile versus the SABC, the Labour Court had the following to say about the resignations. A resignation is a unilateral termination of a contract of employment by the employee. The courts have held that the employee must evince a clear and unambiguous intention not to go on with the contract of employment by words or conduct that would lead a reasonable person to believe that the employee harbored such an intention. Notice of a termination of employment given by an employee is a final unilateral act which, once given, cannot be withdrawn without the employer's consent. In other words, it is not necessary for the employer to accept any resignation that is tendered by an employee or to concur in it. Nor is the employer party entitled to refuse to accept a resignation or decline to act on it. So basically, the conduct of the employee must be unambiguous. It must clearly show the intention that this person has no intention to continue with the employment relationship that will make any reasonable person to believe that this is actually the case. And it's also not up for the employer to accept this resignation. Now, the court further held a resignation is established by a subjective intention to terminate the employment relationship in words or conduct by the employee that objectively viewed clearly and unambiguously evince that intention. The courts generally look for unambiguous, unequivocal words that amount to a resignation. So basically, if an employee say he resigns or he exits the workplace, maybe come in this case like sign his withdrawal forms, he hands in his access card, and maybe if an employer can go additional step and maybe send him a message, a WhatsApp or a telegram or email, just to confirm the sequence of events, to say, listen, we hereby maybe accept your resignation in that you walked out and you portrayed the intention not to return to work. That is normally, based on the reasonable person test, sufficient evidence to say, but listen, this person indeed resigned. Now, what quite interesting is that there's another court development in the African National Congress versus Municipal Manager George Local Municipality and others. Bit of an additional element, a bit of a twist, and saying that they added further that there's another additional requirement where it comes to resignation, being that the resignation must be effective immediately or from a specified date. So this verbal articulation by the employee to resign, or his conduct that basically shows that he has no intention to return, it sort of must allude to the fact, that he does not intend to continue with the employment relationship either immediately or based on a future date, at which date he believes that his employment relationship with the company will terminate. So yeah, that is this case law review for this week. Basically, resignations, what we do learn from this study is that, it is not necessary for an employee always to resign in writing. There are various forms of terminations of employment, and one of these are when an employee has the clear intention to repudiate his or her contract with a company. And this is normally done these days by an employee just absconding, having no intention to return to work, or verbally saying, listen, I'm leaving or I'm resigning. And in actually a rare occurrence these days, they will actually fill in a resignation. But some advice is that when the employee do intend to terminate the employment relationship, but they don't do so in writing, is to reach out to the employee and to say, listen, this is what happened. It seems like you are resigning. We confirm your resignation. We accept your resignation because of the following reasons. You gave in your access card. You told us that you no longer have intention to work. You actually come and completed your withdrawal forms. You haven't been at work for X amount of days, and therefore we are of the view and agreeing to your resignation and termination of your employment. So yeah, that's for this week. See you next week again on Chaile Time. Thank you.